So AB 1078 is pretty new. I think it was amended in September. But it is actually changing a significant amount of stuff related to California gun laws. And so I just thought it would be an interesting thing to chat about.
Let's talk about it. Which one? Now, AB 1078 was which one is that?
I don't know the name of it off the top of my head.
But it's the three and one?
Yes. So
they're
they're doing a lot. They're doing a lot related to CCWs too. So it basically establishes new criteria for folks who aren't residents of California to get their CCW or renew their license. And it's also requiring a little bit more about their live fire shooting. There's a lot of amendments as far as like who can apply and what specific things exempt you from being able to apply as a non-resident. And some of the things were a little bit surprising, like things
give me an
about
example.
Like theft of firearms. There's a rule about if you didn't properly report a theft of a firearm, you can't get a CCW.
That's for anybody, out of state or in state?
I think it's
Anybody.
just. Oh, I thought it was just non-Californian residents.
Let's
let's
clarify it.
So it started. So AB 1078, the biggest part of it is that what they're trying to do is, of course, we got struck down in court, the Wynn lawsuit. There was a restriction where you could only buy one firearm per month.
Yes.
So they're now saying, oh, okay, great. Well, that is unconstitutional. So now we're going to limit you to 3 per month.
Yes.
But then there are other things hidden in this bill.
Yes.
But while you're looking at that, the 3 in 1 month is no different than the 1 in 1 month.
Right.
So it's going to get struck down.
And it's going into effect in April. So as of April 1st, 2026, you'll only be able to get 3 guns per 30-day period.
Yep.
And we already know that the limit was unconstitutional.
Right.
That was decided. So I don't understand what they think I don't get it. I think this is a huge waste of money, and maybe they're just doing it so that we have to spend money suing them over it.
Well,
I don't know.
And if you read the decision in the Wynn case, it didn't say that the fact that it was 1 is what was constitutional. It was the fact that there was a limit that was unconstitutional. So limiting it to 3 is still a limit and is still unconstitutional.
And it's a random arbitrary number.
It's a random arbitrary
factual
number.
basis or reason. Yeah.
So it's going to get struck down. It's going to go to court. Going to get an injunction. All the good things are happening, but that doesn't mean we're not going to stub our toe on the way down the path. You know what I mean? It doesn't mean we're going to get some bad judge who says, oh, no, this is totally different, and I'm anti-gun, therefore I'm going to rule against. Eventually we'll prevail, but in the meantime, we still got to raise the money. We still got to get the attorney. We still got to go to court. We still got to hope for good judges. But what Dakota has found and what Alicia's talking about here is that AB 1078 has even more embedded in it.
So much more.
Yes.
So, okay,
So just to talk about the 3 in 1 for a second, there was also going to be a provision that basically said no matter what happens with that other case, this one's still going to stand. Do you remember that?
Yeah.
So they did get rid of that in Senate amendments. They did amend that out. They removed that provision. So a little bit of a positive note hidden in this awful bill, right?
Yeah.
It's not as bad as it was going to be.
Right.
But yeah, no, there's a lot of other stuff. So
name another bad thing. So if you didn't properly report a pistol or any kind of firearm getting stolen, then they won't let you have a CCW, even though you're not a prohibited person.
exactly.
Which is another thing we're gonna have to. it's another lawsuit. So what else? What else did you find in 1078?
Go ahead. You can.
So what we know is that we know with the Ninth Circuit based on SB2. Last year in September of last year, the Ninth Circuit made a ruling that allowed some of those sensitive spaces to come through, stated clearly that some of those were not prohibited from carry. So the Ninth Circuit decision, let's go back to it, states that we can carry on public transportation, tribal land, healthcare facilities, banks, movie theaters, churches, and public gatherings that require a permit. That came out of the Ninth Circuit based on the SB2 cases last year. But the reason I mention that is if we go here to AB 1078, here's what they're proposing. They're saying existing law prohibits a person who is licensed to carry a firearm from carrying a firearm in specific places, including schools, government buildings. Now, what they're referencing here is because right now we kind of have this SB2 thing, but the Ninth Circuit kind of made a temporary ruling. But SB2 says we can't carry hospitals, zoos, parks, churches, and a bus, train, or other form of public transportation. Existing law exempts a firearm that is secured in a lockbox as specified. This bill would exempt a firearm that is unloaded and locked in lockbox for the purpose of transporting the firearm. right? So, but what they're looking to do is they're looking to basically work against the Ninth Circuit.
Yeah.
So there's just so much confusion about this. There are carry prohibited locations and things are already so convoluted, and there's all this back and forth in the law, and this is just yet adding another layer to that in, out, we can, we can't.
It's
a lot
going
of confusion.
to be so
a lot of
confusing,
confusion.
and nobody's going to know what the actual law is at the moment unless they're basically a paralegal. It's very complicated to understand what is currently in effect and what isn't. And I think one of the things that bothers me so much about that concept is that you are taking normal, everyday, law-abiding citizens and you are making them criminals for crimes they did not know they were committing. And that is atrocious. Why are we trying to make criminals? We've got plenty of criminals already. Let's focus on them. Why are we trying to make more?
I'm sure it's just an honest mistake. They respect our Second Amendment. I'm sure they're just like, well, once we explain it to them, their folly, I'm sure they'll say, oh, geez, you're right. Let's be respectful of your Second Amendment rights. It's absolutely ridiculous what they're doing, but we all know why, and we see this as yet another tactic. Is there anything else you want to point out before we wrap up? What else do we want to point out about? Because I was surprised to hear that there was more than just the 3-in-1 for AB 1078. What's one more?
It seems to it speaks a decent amount to a psychological assessment as well.
Yes.
So we know some counties are doing that. It seems to lend that is likely going to be a push to become more of the protocol within the state. So so right now it isn't that there isn't a psychological analysis when it comes to getting a CCW. It's just that it is what they want to do is actively force you to prove you're not crazy, rather than say, hey, look, I've never gone to, I've never been committed. I've never had a judge, say that I'm harm to myself or others. So it's very similar to the red flag laws, where they're basically saying, hey, we're gonna make you prove, up front that you're not, a horrible, dangerous person, rather than the other way around. Right now, it's that, hey, if you've done something to prove that you're a horrible, dangerous person, then okay, there are regulations or restrictions, that sort of thing. But now they're basically assuming right off the bat you're probably a horrible and dangerous person. You have to prove you're not first before you get to exercise your rights. And if anybody's taken this PSI, which is essentially referencing what this is about, you know that this is not a true, great, reliable psychological assessment.
Right.
Which, have you ever taken the PSI?
I haven't taken it, but
I've taken it.
My understanding, it's a personality test.
It is.
It's not
It's looking essentially. I'm not giving away any secrets. Essentially, what it is it's looking at if you are reclusive, if you enjoy spending time alone, if you don't like being out in the limelight and kind of hanging with friends, you're likely a psychopath. That's kind of what this is about. It's assessing how social you are. It's more of a personality thing. You're correct in that, and it's not, in my opinion, I don't feel it's a valid assessment to what they are looking to do.
Absolutely not.
Right.
Well, and I think this goes back to kind of conceptually, what are we trying to solve here? We're trying to solve really, really, really bad people getting guns and shooting up schools or shooting up churches or whatever. That's what this is attempting to solve.
Or claiming
but
to.
Any psychologist will tell you that it is very, very difficult to analyze whether or not somebody is capable of committing that kind of crime. It's like you need to be the best of the best, and probably this person would have had to be in therapy with you for a long time for you to know, yes, these are the signs that this particular person is going to commit some sort of a heinous crime. It's very difficult to determine if somebody is capable of that. And even if they are capable of it, lots of people are capable of bad things that aren't going to go out and actually do them. So I think the psychological evaluation thing is just a complete mess.
Yeah, no one's going to convince me that it's constitutional to limit someone's right to keep and bear arms so that they can defend themselves, that they can limit that to certain personalities. That's not going to fly. But again, we're going to have to fight it. So this is AB 1078. Check it out. It did pass, but there's more to it than just the 3-in-1, and that's what we wanted to talk about today. So check it out. Hey, thanks for watching Gun Owners Radio. I hope you loved that clip. Don't forget to like, subscribe, comment, and follow us on social media. And check out our website at gunownersradio.com.